Good evening. My name is John Milburn for Central Queensland University. Tonight we're dealing with Week 9 in Land Law, Laws 12066. We changed the order, or I changed the order, mainly to allow for us to finish our discussion on leasing ahead of the second assessment due this evening at 11:45 p.m. Thank you very much for a dedicated group that have joined us for the live session. I suspect they may have put in their work already. Kathleen has joined us, thank you. If you're watching this as a recorded session, what I'll invite you to do now is go to two sources, the Property Law Act and Week 6 material, because tonight we're dealing with the issue of alienability of proprietary interests and perpetuities. Now, I suspect that the only times that you will talk about alienability of proprietary interests is when you're studying this topic, because in, I don't know how many years of I've been studying law and practicing law since 1977, pretty much every day, and I can say that the only times I ever refer to alienability are when I first studied property law and now when I teach it. So rather than explain what those terms mean, I'm going to cheat this evening and refer you to a text that I think is very useful. If you don't have an Australian Law Dictionary, it's probably worth getting. This one is very good. I'll give it a plug. Australian Law Dictionary, this is Oxford Press. Okay, alienability of proprietary interests and perpetuity is the topic for this evening. Let's break that down so we can talk about it in more English. Firstly, alienability, what does that mean? It says in the dictionary that I'm referring you to, the transferal of property rights, voluntary or involuntarily. Alienation may be effected inter vivos, we know what that means, during your life, by deed, agreement or gift, or by will or administration in intestacy, so as opposed to inter vivos. Alienability is an inherent attribute of property. And at common law, alienability of estates in land was protected by the rule against perpetuities. Okay, so we know what alienation now means, the transferability of proprietary interests in real estate, either inter vivos while you're alive or through death. So that's one word catered for. Now, we mentioned, it mentioned perpetuities. So let's go and have a look at perpetuities. What does that mean? Again, looking at the dictionary. Actually, before I get to that, I'll talk about, what word am I looking for here? Sorry. To vest. It talked about vesting. Vesting is putting something into possession. To vest something, property, in someone is to establish it securely in that person's legal ownership or possession. That's what we mean by the term vesting. Then we have the term remoteness, because that is inherent in perpetuities, and remoteness is the reason a court will deny recovery for a claim where the loss of a kind is not reasonably foreseeable. No, I'm sorry, I'm just going to gloss over that because that's not what I'm trying to establish here. My apologies, I'll go straight to perpetuities. So perpetuities means trusts designed to last effectively forever, having no discernible vesting date, see vest, that's what I'm trying to find earlier. The common law rule against perpetuities, that the vesting date could not be postponed beyond the perpetuity of some life in being plus 21 years, has been modified by legislation. All right, so what we take from that is that we're talking about the way in which there might be some form of unreasonable restraint on a person's ability to deal with their property. So we're talking about issues of remoteness, of vesting, as it's sometimes known. And when we talk about remoteness, which was the definition I was looking for, I'm not sure that I can find it quickly. And I can't. So, remoteness. No, I'll leave you to look that up. Sorry. So what we're talking about is a restraint on the ability to sell something or transfer something in the property, either forever or for a very long time. So an attempt to stop the alienation, the ability to transfer property indefinitely, breaches the rule against remoteness of vesting. That is the rule against perpetuities. The general proposition, as mentioned in the dictionary definition that I've read to you and reflected in the common law, is that the perpetuity period extends to the lifetime of people alive at the date of creation of the trust, and we add to that 21 years from the date of death of the last survivor of those people. Have I lost you already? Because perpetuities is tricky. That's why I'm suggesting at the outset that when you study perpetuities, get yourself the dictionary, understand the terms so that you can refer back to them, and that might make it a little easier. Now, of course, it's all very well to say that's the rule, but trying to determine the life or lives in being itself is problematic because it's an evidentiary issue. Sometimes, in the older days, if you look at older documents, drafters would try to choose an identifiable figure. The common example is King George V. We say that's a common example because it was referred to in a case, Clay against Carlson, 1998, 19 WAR 287. So it doesn't matter what life we're talking about, we're just talking about a life or an identifiable life of a person alive at the time of creation of the trust, and the rule against perpetuities is 21 years after the date of death of that individual or that person who has formed a part of a group. So that's the common law position. It was well stated in the case of, this is common law position, Air Jamaica against Charlton, 1999, 1 WLR 1399, where the court said, no interest is good unless it must vest, if it vests at all, within a period of life in being, the date of the gift plus 21 years. A gift is defeated if, by any possibility, that's key words, and we'll talk about that shortly, however remote, it may vest outside the perpetuity period. It is not saved by the fact that in the event it vests inside the period. So when we talk about perpetuities, we're really talking about this issue of the possibility of the gift or the interest vesting outside that 21-year period. It doesn't matter factually whether it occurred or not. It's a question of whether it's possible, even if it's a remote possibility. Now, what do we mean by the word vest? As we said before, I think, to vest something is to establish it securely in the person's legal ownership or possession. Something is vested or has vested if it is in their possession from a legal perspective. Okay, again, looking at the dictionary. In Nemesis, Australia against Commissioner of Taxation, 2005 FCA 1273, that's Nemesis, Australia, Pty Ltd, against the Tax Office. Justice Tamberlin said, as pointed out by the Queensland Law Reform Commission in its 1971 report called On the Law Relating to Perpetuities and Accumulations, the rule against perpetuity performs a useful social function in limiting the power of members of generations past from tying up property in such a form as to prevent it from being freely disposed in the present or in the future. And that's really the key. The rule against perpetuities is to stop people, we say, ruling from the grave. if you provide someone with property or an interest in property, the rule against perpetuity says give them a chance to actually use it, to vest in it and deal with it as they see fit. All right, now if we have any questions as we go, please stop me and ask the questions or unmute your microphone. So effectively, under the general law, the rule against perpetuity voids an interest which may vest, if it vests at all, more than 21 years after the date of the life of a being, someone who's alive or someone who's in the womb at the creation of the interest. If no such life was in existence at the time, then only 21 years is allowed. So do we kind of get an idea of what this rule is about? It's to stop restraints, which is the restraint on alienability of property at some stage. But that common law rule that I mentioned is modified by statute. Now I mentioned at the start, please have the Property Law Act handy. So now I'll refer you to section 209. Please call that up on your screen. If you're following this as a recorded session, please do likewise. I'd like you to look at subsections 1, 2 and 3, which provide for the power to specify the perpetuity period. So this is still, it's not academic, it's still very much part of our law. I'll just read through the subsections. Except as otherwise provided in this part, where the instrument by which the disposition is made so provides the perpetuity period applicable to the disposition under the rule against perpetuities, instead of being any other duration, shall be such number of years not exceeding 80, as is specified in the instrument. Subsection 1 does not have effect where the disposition is made in exercise of a special power of appointment. And then in number 3, subsection 3 says, if no period of years is specified by the instrument, but a date certain is specified in the instrument as the date on which the disposition shall vest, the instrument shall be deemed to specify as the perpetuity period applicable a number of years equal to the number of years from that date. Okay, when you read that, have I ever mentioned that the Property Law Act is not very well drafted, in my view? At 10, I think that's 12 times now. I'm going to ask if you could listen to this because I think this is how I can describe section 209 in English. So this is what I make of section 209. The period of perpetuity cannot exceed 80 years, or the general law position of the interest in property may apply. And the general law rule says that a trust must not exceed further than 21 years after the date of death of a party who was alive during the period when the trust was created. At the end of the 80 years, or earlier, if the trustee determines, the trust will vest or cease. The trustee will, at that time, get in all of the trust property and either convert it to cash or pay a cash distribution to beneficiaries, or will pay in specie distribution to beneficiaries. And the duration of the trust may be extended or shortened if all concerned agree. Now that was a bit quick, but I think that's a more realistic explanation of the statutory provision, section 209. So in short, perpetuity period can't exceed 80 years. If it does, we look at the general law. General law talks about a life in being plus 21 years. And what's the consequence? At the end of the 80 years or earlier, if the trustee determines, the trust will vest, it will cease. The trustee at that time will get in the trust property, convert it to cash, pay distributions, or distribute property in specie to the beneficiaries. And the duration of the trust may be extended or shortened if all concerned agree to this. I think that's what section 209 really means. I hope that makes some sense. If you're struggling, please play the recording back again. Read section 209. If you come up with a better version of how to interpret that, please let us know through UCRU or some other means. Let's look at a case, and I'll just see any questions at this stage. No? All right. Let's have a look at a case. Yeomans against Yeomans, 2005, QSC 85. This is to do with a will. Now, in the will, the testator left a disposition to establish a trust, which is not uncommon. We see testamentary trusts regularly in wills. And the trustee said, for the benefit of my grandchildren, with an entitlement to pay from the trust at the discretion of the trustees. Now, on the face of it, you'd think that's pretty good, but there's some issues with that. The first is, do the class closing rules apply to limit grandchildren to those alive at the death of the testator who created the discretionary trust with no express perpetuity period? Does the general law perpetuity period therefore apply? And indeed, was the trust void for vesting outside the relevant perpetuity period? So there's a few issues there from what would seem to be a simple will. Here's what the executor argued. The executor said that the perpetuity period was 80 years from the date of death, referring to section 209 subsection 1 of the Property Law Act. As the trust fund was not bound to be distributed within that period, the clause would be invalid under the general law. He submitted, however, that the wait and see rule under section 210 applies, so therefore clause 5 was not invalid. I know this is tough. This will be the toughest, probably the toughest section of studies that you have. So have a look at section 209 and then have a look at the wait and see rule, which is in section 210. I hope that makes some sense. Now, there is an opposing argument. The opposing argument was that the perpetuity period would expire 21 years from the last life in being, which would be the last of the living children of the testator who produced grandchildren. That kind of sets the scene. That's how Justice McMurdo dealt with this. If you look at the case, look at paragraphs 21 and 24. Paragraph 21. Under section 209, an instrument may stipulate any perpetuity period and a number of years not exceeding 80. So we got that. But this did not do so, and section 209 is not relevant. The perpetuity period is that under the general law, which is a life in being plus 21 years. Or if there is no life in being, simply 21 years from the testator's death. I hope you're with me still. The life in being must be mentioned in the gift, either expressly or by implication. The relevant, the implication, where there is a gift to grandchildren, the lives of the testator's children help to confine the period of time within which the gift can vest, so the testator's children can be taken as the lives in being. Now, Justice McMurdo took that content and acknowledged Lewin on Trusts, 17th edition, at 524, 5-24. Paragraph 24, the fourth respondent will be appointed also to represent the unborn grandchildren. It will be declared that upon the true construction of the will, clause 5 is valid, and the word grandchildren includes grandchildren born after the death of the testator. It will be further declared that the class constituted by my grandchildren, as referred to, shall not be confined by reference to the age of any grandchild. I'm going to ask you just to look at that case, look at just those two paragraphs, and if you can work your way through that, particularly paragraph 21, that kind of goes to the heart of the discussion. Let's look at trusts that infringe the rule against perpetuities. Now, an attempt to stop alienation of property indefinitely breaches the rule against remoteness of vesting, that is the rule against perpetuities. We know that. That's what we established at the start of tonight's seminar. Are you with me so far? So we know what the general position is, and we know what we mean by lives in being. So we know that that position, which is really in trusts, is modified by section 209 of the Property Law Act. So really what I've done there is just give you a summary of the position so far. That's the logic. So when you're looking at perpetuities rules, go to section 209, have a look at the wait and see rule in section 210. Be aware of what the common law position is, because that is specifically referred to in section 209. If you're having troubles understanding that, piecing it together, have a look at paragraph 21 of the case of Yeomans and Yeomans, and you'll see that Justice McMurdo explained that in a kind of fluent way. Superannuation, which is a trust. The statutory provisions do not apply to superannuation entities. It's not in the Property Law Act. It's in section 343 of the Superannuation Industry Supervision Act, 1993 Commonwealth. It is actually also in the Property Law Act, sorry. Have a look at section 220, which excludes superannuation funds from the rule. So there's two sections there in relation to super. The Super Act, Commonwealth, section 343, and the PLA at section 220. I'm just going to do a little bit of a refresher again. I'm sorry to do this, but when I was preparing for the lecture, I thought I'm just going to do this by going back and bouncing back, because if I just go in a monologue and I just flow through it, there's a very real risk that I'll lose you, and I don't want to do that. So let's have a look at some of these key terms again. Again, I've got my trusty dictionary. Remoteness of vesting. Do we know what remoteness of vesting means? If I said, beat the buzzer, what does the remoteness of vesting? Oh, perpetuities, yes. Any other thoughts? Another phrase? Chance of it taking place, yes. Yep. How about this? Means the likelihood that property will not vest within the perpetuity period. So I've taken a combination of both those responses. Thank you. So that's what we mean by remoteness of vesting. Scott says taking place outside the period, and it's to do with the likelihood issue is the remoteness of vesting. It's the likelihood that property will not vest within the perpetuity period. Remainder. What do I mean by remainder? Particularly in the context of a will, or we talk about remainders in the context of leasing. Do you remember that? We talked about the remainder. It arises where a grant is designed. Yeah, what's left? Yeah, that's it. Arises where a grant is designed to take effect on the natural termination of an earlier possessory freehold estate is the technical meaning, but I think what's left over gives a better conceptual meaning to it. And reversion is the same sort of thing, where the holder of the freehold grants a lesser interest and thus does not dispose of the entire property. So we'll call that a reversion as well. Perpetuity period, again, have a look at section 209, have a look at nemesis against Commissioner of Taxation, and be aware of the common law position because it's referred to. If you have the text Real Property Law in Queensland, Chapter 7 provides some practical explanations as to how the modern rule operates in Queensland with some worked examples. There's reference to that in your study guide. I know that's not the prescribed text, but if you have access to Chapter 7, it has some material. It's a very long chapter. I'm not sure I can reproduce it for you. But we'll go through some of the steps.
John,
so, yes, indeed.
Yeah, John, just
yes, go on.
The perpetuity period, just trying to get my head around it. So if the instrument's silent about the 80 years, then it's the life plus 21. But if the instrument actually specifies a number of years, that number of years must be less than 80, and it's whatever the number of years is. Is that correct?
Yep, so the starting point, so that's a really good question. Thank you very much. So where do you think the starting point is that we should look at in Queensland when we're talking about the perpetuity period? So we look at the section 209 and work through that definition. So what I'll do to answer that, Scott, we'll go through some step-by-step process, and hopefully that will answer it. So the first step, I think, is this. Ask yourself, is the limitation period which is contained in the instrument one to which the rule against perpetuities may apply? I mean, for example, if you're looking at a contract and it says settlement will occur on 30 days from now, you'd say, well, clearly perpetuities has got nothing to do with that. It's got a date, it's got a time period in it, but it's not something contained within the instrument to which the rule against perpetuities may apply. I think, so the thing is, you look for things like trusts and longer term interests. So the rule against perpetuity applies to contingent remainders and executory interests, not to vested interests. So that's the first thing, Scott. If you've got something which is a vested interest, where it actually has vested, then it's fine. But if it's an executory interest, if it's something down the track, then that's different. What do we mean by executory as opposed to executed? Remember that in contract law? I'll take an example of a standard real estate contract. You sign a contract to buy property. That's an executory contract because it doesn't immediately transfer the interest. There are steps to be completed before the final transfer occurs. So in that sense, we call it executory. So when we're talking about perpetuities, we're not looking at something where there has already been a vesting of the interest. We're talking about something which is a contingent remainder or some sort of executory interest where there's something down the track to occur. That's number one. Step number two is, what is the date of creation of the interest? In other words, in a will, it takes effect on the death of the testator. That's the date of the creation of the interest, not when the will was signed. If it's something inter vivos document, it is the date of the instrument. So that's the second step. Think about the date of creation of the interest. Third step is this. What is the life in being, or what are the lives in being? So in order to constitute lives in being, condition number one is measure the life. It must be human life. We're not talking about animals, for example, or we're not talking about the life of a tree, which might be hundreds of years old. So it's got to be human life. Number two, it's got to be measuring the life or lives in being at the date of creation of the interest. Number three, if there's a group used to measure the lives, the group cannot be capable of increasing in number after the date of creation of the interest. And number four, if there's a group of people used in measuring lives, that group must be ascertainable. So you can't simply say, anyone who's alive at the time of creating this instrument, or anyone who's alive at the time of my death, because you can't ascertain that group. It's too large. So I know this is a very long answer to your question, Scott, but hopefully we'll get there. Step number four is ask yourself about this issue of remoteness of vesting and possibility. Is it theoretically possible, this is step four, is it theoretically possible to construct circumstances in which vesting will occur outside the perpetuity period? So here's the answer. If at the commencement of the perpetuity period, it is theoretically possible to construct circumstances in which vesting will occur outside that period, the rule against perpetuities is infringed. So that's the common law approach. Now, To answer your question, Scott, I need to go to the statutory modification, but I just want to make sure that we understand the common law approach and maybe some steps to, to fill in some details to that. And I will now get you to concentrate because I want to work through an example of the common law approach to perpetuities. So if you just make some notes on this. By settlement inter vivos during one's life, S conveys a property. We always call these properties Blackacre. I don't know why, we just do. So S conveys Blackacre to trustees. Upon trust for such of my grandchildren as shall attain the age of 21 years. So we got that? At the date of the settlement, S has 2 children, aged 3 and 1 respectively. Got that? So we'll say B is aged 3 and C is aged 1. Now there are 4 steps that we need to consider. Number 1, and these are really the second condition. Step 1, given the beneficiaries are not yet ascertained, we don't know who the grandchildren are, the limitation is a contingent remainder to which the rule against perpetuities applies. Step 2, the date of creation of the instrument inter vivos is the date of the instrument that it takes effect. That is the date of settlement. It's not in a will. So we know that this is the rule against perpetuities is live. We now know the date of the instrument. Step 3, the only person who satisfies all 4 conditions is S. Her children cannot be lives in being because at the date of creation, at the date of settlement, S might have had more children. Therefore, conditions 3 and 4 are not satisfied. I'll just stop there. So we've identified it's a perpetuities problem. It has that look of perpetuities about it. We know it comes into effect. The date that we're talking about is the date of the instrument. And the person who creates the settlement, S, may have more children down the track. Therefore, that is the life in being that we're talking about. So at the date of creation, S had no grandchildren. Therefore, pursuant to condition 2, her grandchildren cannot be the lives in being. And therefore, this hopefully answers your question a bit more, Scott. The perpetuity period in that circumstance is S's life plus 21 years. So it wasn't stated as such, but if we think through logically the rules in common law, that would be the answer in that case. Step 4, it is theoretically possible to construct circumstances in which vesting would occur outside the perpetuity period. S's children could have children who are born after the date of S, the death of S, therefore will not reach the age of 21 years within that perpetuity period. Therefore, the limitation offends against the rule against perpetuities and therefore is void under the general law, because there was a chance that there might be a remoteness of vesting outside that perpetuity period. The rule against perpetuities says you can't have remoteness of vesting outside the perpetuity period. If you do, the document says it's void, and that's a common law. That was a very long answer, and I still haven't answered your question fully, Scott. So let's have a look how that situation might be modified by statute. So we're considering sections 206 to 222 of the Property Law Act. What we're really doing is we're adding a 5th step to the process. Step 5 says, all right, given that the common law is now modified by statute, let's look at the statute, and it says, can a limitation that is void under the general law be saved through application of the statutory modification rules contained in Part 14 of the Property Law Act? And when determining whether a statutory modification to the rule needs to be applied to save the gift, here are the things and here are the sections that you need to consider. First, you need specific modification of the general law rule such as power to specify a perpetuity period, which is section 209. You need to consider presumptions and evidence as to future parenthood, which is section 212. And you should be following your Property Law Act and making notes at the same time. Then you need to consider unborn husband or wife, section 214. That's the first lot. The second, you need to consider the wait and see provisions, section 210. You then need to consider the reduction of age provisions, 213, subsection 1, and the exclusion of class members to avoid remoteness, which is section 213, subsection 3. So they're the statutory provisions that might be relevant in this case. Now, under the general law, the rule against perpetuity voids an interest which may vest, if it vests at all, more than 21 years after the date of a life in being or someone in the womb. I know I've probably said that 6 times already tonight, but I'm just trying to reinforce it. That is at the date of the creation of the interest. This is inter vivos. We know the date of the creation of the interest is the date of the settlement. Section 209 provides power to specify the perpetuity period of up to 80 years. So, if a perpetuity period or vesting date is specified, there is no need to consider the validity of the limitation of the general law. In other words, section 209 applies and it simply dispenses with steps 1 to 4. It gets rid of the common law. So we look at 80 years. That's if the perpetuity period or the vesting date is specified. You don't need to look at the validity of the limitation. Section 209 applies. Now, I've mentioned section 210, the wait and see rule. Have a look at that if you're following now the Property Law Act. I want to just stress some parts of it that might assist when you're trying to understand it. Look at subsection 1. It says, where apart from the provisions of this section and section 213, a disposition would be void on the ground that the interest disposed of might not be vested until too remote a time. And this is the important part. So where that may occur, because it might be too remote, subsection 1 says this: the disposition shall be treated until such time, if any, as it becomes established that the vesting must occur, if at all, after the end of the perpetuity period. So that's what we mean by the wait and see rule. And you can read subsections 2 to 5 for yourself. So let's see if we can make a bit more sense of that. So under the general law that we've talked about, it's the possibility that interests may vest outside the perpetuity period that invalidates any disposition which involves that possibility, even if it's remote. The examples that we use are the magic gravel pits, which is referred to in your notes, where the gravel pits, the evidence was that the gravel pits would be exhausted after 4 years of the date of the testator's death, which is clearly within the 21-year period. But in fact, they were exhausted 6 years after death. But that didn't matter, because the court said, we're not concerned with reality, we're concerned with possibilities. And therefore, because there's a possibility that the gravel pits may still be producing after 21 years from the date of death of the life in being, that at law is an invalid gift because it offends the rule against perpetuities and remoteness of vesting. Oh, it's a lot of words, I know. The rationale of that case being that it was possible, theoretically possible, that the pits would not have been exhausted until 21 years after death. Now, the wait and see rule, section 210, is an attempt at least in part to overcome that type of problem. The rationale of the wait and see rule is to consider the limitation not from determining possibilities at the date of creation, but rather to consider what actually occurs. And that makes a lot of sense. So clearly the magic gravel pits was not a case considered within the context of Section 210 of the Property Law Act. I mentioned earlier Nemesis Australia against Commissioner of Taxation. I'll refer back to that case. I'll refer you to a different section this time. But firstly, in this case, what happened was the Commissioner of Taxation purported to attack, by the imposition of high rates of tax, appointments of income made pursuant to a discretionary trust. The arguments related to whether the payments made could be justified under the terms of the trust. So the court was required to consider the terms of the trust and whether it breached the rule against perpetuities. That's kind of the background to it. The important part, and I'll refer you to two paragraphs of the case, paragraphs 39 and 49. The first, 39, goes some way to explain the rule, I think. And the court said this: Section 210, subsection 1 of the Property Law Act, which is the wait and see rule, provides that where a disposition would be void on the ground that the interest disposed of might not become vested until too remote a time, the disposition shall be treated until such a time as it becomes established that the vesting must occur, if at all, after the end of the perpetuity period, as if the disposition were not subject to the rule against perpetuities. Does that make sense? I know that's a lot of words. So what the court is saying is that the way in which the wait and see rule works is, as the name implies, rather than consider the possibility that something may vest outside the perpetuity period and therefore by the rule against perpetuities be void, let's actually wait and see. So the gravel pits case would have been decided differently by using Section 210. And that's the whole idea of Section 210, to modify the harshness of the general law. Have a look at paragraph 49 of the judgment, where the court says, in view of my conclusions in relation to Section 210 and the operation of the wait and see rule, none of the income dispositions are invalid for breach of the 80-year rule, and it's necessary to wait and see what in fact happens within that 80-year period before it can be established that the fund must vest outside that period. That's how it was applied in that case. Now, I've mentioned a few other sections. Have a look at Section 211, which is power to apply to a court for a declaration as to validity. So rather than having to wait and see or guess, a trustee or an executor has this important power to go to a court and say, we're concerned, we're not sure, please tell us, is this valid or does it breach the rule? Section 212 of the Property Law Act talks about presumptions and evidence as to future parenthood. This is what they call the precocious toddler issue in common law. So Section 212 says, where in any proceedings there arises on the rule against perpetuities a question which turns on the capacity of a person to have a child at some future time, we're going to introduce some presumptions. It's presumed that a male can have a child at the age of 12 years or over, but not under that age, and a female can have a child at the age of 12 years or over, but not over the age of 55. Or in the case of a living person, evidence may be given to show that he or she will not be capable of having a child at any time. So they're kind of sensible presumptions to add a bit of certainty to this situation, because earlier cases would suggest that perhaps even children less than 12 or females older than 55 could still have children. Section 213 deals with the reduction of age and exclusion of class members to avoid remoteness. So again, all of these provisions are designed in essence to prevent the harsh rules against perpetuities and rendering void documents that might otherwise be saved. So these statutory provisions try to save the instrument or the gift. Section 213 talks about reduction, and the section saves some gifts that would otherwise have breached the rules against perpetuity. Assume that a settlement provided for a gift of property to trustees upon trust for such of my grandchildren at the age of, say, 25. At general law, the gift would have been void, but assume that at the end of the perpetuity period, the settlor had 3 grandchildren aged 23, 19 and 15. By application of the wait and see provisions, the gift will not vest within the perpetuity period, but section 213 can save the gift to the younger child by reducing the specified age from 25 to 19. The gift cannot save the gift to the oldest child. It doesn't permit an increase in age. Now, from the study guide, you'll see a graph or a chart which talks about steps for resolving a perpetuities problem. So I'd ask you to look at that in the study guide because it says here are the steps that you need to consider. Firstly, determine the date of creation of the interest. Essentially, it'll be the date of the settlement or the date of the document if it's inter vivos. It will be the date of death if it's a document which is a will. Secondly, you've got to determine who is the life in being. Thirdly, if appropriate, apply the old rule against perpetuities. If it is a class gift, then apply the common law rules. Then look at the statutory reforms. Are they applicable? If they are, apply them. Then apply the modern rule against perpetuities. Determine if the statutory reforms are applicable. If so, apply them. And then finally, if any of the interests have infringed the modern rules, determine the consequences. So in order to talk about the modern rules, and I'm getting close to the end here, you'll be relieved to hear. I just want to go back to what I think Section 209 of the Property Law Act actually says. This is just a refresher on what I said earlier. So the period of perpetuity cannot exceed 80 years, or the general law rule of the interest may apply. So I think, was it Scott who asked the question? If the document actually says a number of years, go with that. You don't have to worry about the rule against perpetuities, but it can't exceed 80 years. If it says the vesting will occur in 100 years, for example, then we have to look at the general law, the general position. And so what does the general law say? It says a trust must not exceed more than 21 years after the date of death of a party who was alive during the period when the trust was created. That is the life in being, or the lives in being. At the end of that 80 years, or earlier determination, the trust will vest or cease. The trust will, at that time, be in the trustee's hands to convert to cash and distribute it, but those durations can be extended or shortened if all agree. I hope that's provided some assistance, but I know it's a tough area. Are there any questions? Are we shell-shocked? Don't worry, I reckon this is, to me, this is the hardest thing out of the whole law degree that you'll do. Aaron says, that was the bit about the precocious toddlers and the fertile octogenarians. Yes, that was it, when I was talking about those presumptions in relation to the age that people may have children. Sarah asks a very good question. Will it be in the exam? And the answer is, I can't rule it out. I'm sorry. But what I'm going to ask you to do is this. Just try not to overthink it because it'll do your head in. But try to work out, I mean, the main sections, just have a little bit of flow chart that works for you. So look at the flow chart in the study guide. If that works for you, great. If not, just expand your thinking a bit more. If you can work out a little flow chart, then it'll fall into place, hopefully. And don't be too stressed over it. Okay. Any other questions? If nothing works, will it not be on the exam? I can't say for sure. It may be on the exam, sorry. All right. I'll try to get the results to you in relation to the second assessment quickly. I can't promise I'll get them back to you as quickly as I did the first assessment. And I might take a different approach in terms of how to provide you feedback. What I may do this occasion is something that I do for the ADR work and evidence in proof, where I prepare a document and then I provide some commentary about your document within my document, if that makes sense. The risk is that if I send your document back with corrections, it just looks a bit headmasterish or headmistress, you know, with the red line going all the way through it, and I don't really like that. I don't mind it at times, but I think I'll try and adopt a slightly different, more positive approach to the assessment regime on this occasion. And I haven't formalised that. That's the way I'm thinking at this stage. All right. Well, thank you very much for your patience, and we'll see you all next week. All the best. Bye then.